Right. Good morning, ladies and gentlemen. Welcome to another episode of PLA with myself, Nick and Bruno. We've got two questions today and we'll be dealing with them right away. The first question comes from Caitlin on Facebook. Caitlin says that a friend of hers owns a unit in a sectional title scheme. There is a large patio, Nick, of her downstairs. There's a very large patio that's on top of a downstairs neighbor's lounge, right? During heavy storms, there is a leak that is being experienced. And so what is happening is that the leak is not coming from the pipes, but rather only occurs when there's heavy rains, and then it goes straight into the actual lounge of the actual neighbor downstairs. The owner of the top unit obviously has now gotten contractors to look into the matter and ripping up the patio and waterproofing it, which has become expensive. But now the issue is that the contractors cannot guarantee that this will solve the issue. The Brodie corporate has then gone and given the owner of the top unit 60 days to repair the leak, failing which the matter will be obviously referred to CSOS. The owner of the top unit obviously doesn't want to incur the significant costs, as obviously it might not even solve the issue. Then the question then at the end then becomes that Caitlin asked, is the resolution of this leak the responsibility of the owner of the top unit? What is obviously some of the Brodie corporate's responsibility in ensuring proper drainage? And so what if the leak is resulting from an expansion? So maybe we can just basically, who's liable to be fixing this? Is the Brodie corporate? Is it both of the tenants, one of the tenants? Does it depend on what the actual issue is, structural and expansion? So maybe Nick, just dive into it and maybe just give us a sort of a broad answer relating to this, please.
Perfect. So I think what's important when we start with a question like this is to just highlight some of the areas that are in operation within a Brodie corporate. Okay. Now, obviously, a Brodie corporate that is established has plans. Okay, and those plans have to be approved, and they set out on those plans where everything within a particular piece of land is going to sit. Okay, and within that, obviously, you've got all your units that you'll see in a Brodie corporate, and they will sit in individualized sections. And those units, after the development of the scheme, get sold to individual owners, and those units are owned by the individual owners. That's an easy thing that we all know about. Okay, but so those particular areas that have been designated as a home or an apartment or whatever the case is are owned by the individual owners. But those are not the only pieces of land within the scheme. Okay, something else that exists, common areas. Okay, now we know about common areas. You know, it's spaces within the scheme to get to your particular unit, your particular apartment. Okay, common property, anyone's entitled to use it in the circumstances, and the ultimate responsibility for common areas is generally the Brodie corporate to look after those common areas. Okay. The other thing that they can be in terms of the scheme is what we call an exclusive use area. Okay, now an exclusive use area doesn't necessarily fall under ownership of the particular owner. Okay, so it's not part of their unit perhaps, but it's an area which is designated for use by the owner of that particular unit. So the easiest example you can think of in a Brodie corporate is where someone perhaps has a garden which is attached to their particular unit. Okay, that garden may well be an exclusive use area. So it's an area which is designated for use by the person who owns this particular unit. That's why there might be a wall around that particular garden. Depending on the scheme, okay, and how the plans of that scheme are drafted, that garden could either be part of the unit perhaps, or an area which is designating an exclusive use area, so it's for the use of that one particular person. What's important to understand about an exclusive use area is the maintenance of that particular exclusive use area still remains with the owner of that particular unit. So they have a responsibility to look after that exclusive use area. The reason I mention this is generally when we look at Brodie corporate schemes and when you look at the plans of Brodie corporate schemes, something like a balcony may very well fall under an exclusive use area rather than a designated part of the owner's property. But in this particular circumstance, we don't know what this particular balcony might fall under. Okay, it does say it's above someone else's living room, I think it said. So it's certainly part of the building, but we don't know exactly what that roof area looks like. In any event, as I've said, the exclusive use areas, if it's designated to a particular unit, you do have a responsibility to maintain that particular exclusive use area as the unit, as the owner of the particular. So my assumption would be that there's a responsibility on the particular owner of that unit. Okay. However, there is a provision to this particular question, because it seems to me that they say that this is it's not a drainage problem or anything like that. It seems to be something that is occurring as a result of rain at the particular body corporate. And so there is some form of waterproofing, damp proofing, or maybe even some structural integrity that's not all the way there. Okay, that's what's resulting in this particular leak in the circumstances. If that is the case, and there is some argument to be made that it's a structural thing, that the building itself has got a problem, okay, it may be argued that it's going to fall into the body corporate realm. Okay, body corporate is going to have an insurance policy which is going to deal with structural integrity of the building, so it would be covered by the insurer in the circumstances. But what is very important in cases like this, and all cases when it comes to body corporates, leaks particularly, we've said it before on our previous things. When it comes to leaks and structural stuff, you need to know exactly where that leak is coming from. You need to get experts in to say, okay, where is this fault deriving from exactly? Because only with that sort of information are you going to be able to determine, okay, cool, does it fall within the owner's hands? Does it fall within the body corporate's hands? Who's responsible in this circumstance? So I know they've had someone come in and have a look at it and said that they need to, tear up the patio. In the circumstances, I don't know whether that's going to be a structural problem. It certainly sounds like if you've got to rip up the whole patio to now get the waterproofing in. I don't know, Bruno, if you'll agree with me, that seems like it's alluding to the fact that there's a problem with the actual building itself, which may fall into a body corporate problem.
No, exactly. Look, I feel the same way, and I think the problem over here is that there's sometimes a fine line between what's legally allowed and obviously the construction industry and how things are actually built. So where I'm not sure, for example, is how much obligation is there on a specific owner to do certain things, and is there anything to be done? So with a patio and the build of a patio, are there any obligations on the owner to do maintenance? Because like you mentioned earlier, if there is a maintenance obligation, so let's say, for example, it's gutters that get full of leaves, right? And now there's an obligation on the owner to actually clean these gutters. If you don't clean the gutters, the water would obviously not flow through the gutters and it would start causing leaks and it goes downstairs. So I'm not saying this is a gutter issue, but hypothetically it could be, because it's a patio and there's gutters along the edges. Now, in those circumstances, absolutely. Top owner, you should have maintained properly. If now the situation actually got worse and damage was caused because of your lack of proper maintenance, sorry for you, right? But again, from a construction perspective, is it that simple? Like if a patio is built properly, and listen, we never, because I mean, we've had patios plenty of times, where it simply doesn't leak. It's built in a very particular way where it doesn't leak underneath. If patios carry that standard of construction, then to answer the question, then it is definitely structural, because why is it leaking now? And why do other patios that are built properly and that people expect to be properly built patios don't leak? In that instance, I would say absolutely, it has to be a body corporate thing, because at the end of the day, the structure itself, short of maintenance by owner, would actually fall within the ambit of the body corporate's responsibilities.
Yeah, absolutely.